2. Nationality of corporations. Systems proposed. How is such nationality determined? In order to declare the newborn child subject of a certain state, recourse can be made to only one of the two following circumstances, which, in attaching it at the moment of its birth to a person or and thing possessed by this state, make of it as one of its natural appurtenances, viz., the territory upon which this birth has taken place, the parents to which the birth is due. When it is a question of attaching, at the moment of its constitution, a corporation to a state, a solution presents itself immediately to the mind. Who says corporation says contract, or at least an ensemble of rights and obligations born of an initial contract. According to the nationality which will be attributed to it, the corporation will produce very naturally, from very different important points of view, different results. Is it not logical to seek by all means the nationality which the parties have wished to attribute to the corporation they create? This idea has been expressed more or less clearly, sometimes with much force, by the majority of the speakers of the two congresses upon joint stock companies held in Paris in 1889 and 1900. We shall see that it has inspired two at least of the systems that are going to be presented. Therefore, I shall have occasion to speak of them again. It is necessary to lay them aside until then, for it has the effect of allowing the interested parties to withdraw themselves from imperative and prohibitive rules whose application or non-application constitutes precisely the problem of the nationality of imaginary beings. The French law imposes on civil and commercial corporations to which it applies a condition that some consider hard and troublesome, and from which results by comparison a situation enviable for foreign corporations which operate in France without, nevertheless, depending on French public power and law. The organizers of a French company could not put aside directly by a clause of the organic, constitutive, act those of its legal provisions which are not interpretative or suppletory. They can no more put them aside in referring themselves to the rules of a foreign law, and it is this last course they would pursue if they attributed to their company a nationality chosen with the sole object of checking these provisions. Useless to insist upon a truth so simple. Its evidence is such that those who disregard it do not do so openly, but, in attributing to the parties the right of choosing a foreign social nationality, they subordinate the validity of this choice to the realization of a condition which implies or presumes it. The nationality, therefore, of a corporation can no more be determined by the will of its organizers than the nationality of a newborn by the will of its parents. There could be no question in the first case of jus sanguinis or of jus soli as in the second. The embarrassment is greater. One can hesitate between 5, perhaps 6, facts which themselves establish or seem to establish, respectively, between this corporation and this state a relation whose logical force it is sometimes more easy to feel than explain. Authorization given by a state to the constitution of the corporation, country upon whose territory this constitution has taken place, nationality of the associates, country of subscription or domicile of the subscribers, finally, social domicile, expression which can be taken in two different senses and thus mean two distinct things. Such are the facts, capable, moreover, of being combined, which are presented to the mind in search of a criterion permitting it to distinguish domestic corporations from foreign ones. What are then their value and their meaning? First system. The corporation takes the nationality of the state which authorizes its existence. Every judicial person, according to M.P. 4, acquires a legal existence by means of an act of foundation approved by the supreme authority, and it is to this act that we must refer in deciding whether the judicial person is domestic or foreign. Every corporation, says M. Vice, is foreign that is formed with the express or implied assent of a foreign state, which in giving existence to it communicates to it at the same time its nationality. The majority of authors presents this solution as evident. They hasten to add that it is rarely applicable in fact because, almost everywhere, the different corporations are established without any authorization being necessary, this condition having been maintained only in some countries and only for joint stock companies. This suffices, nevertheless, in order that this system may not be purely theoretical, and merits justification. It can be done by considering the corporation authorized as a creation of the state which has given it judicial life by the fiat of this authorization, or more simply by supposing in this state the sovereign will of treating this judicial person as its subject. Let us now remark that this proposition is purely gratuitous. Where it is yet exacted, governmental authorization is imposed on foreign as on domestic corporations. Foreign joint stock companies can operate in Russia only after their statutes have been examined by the imperial government and the ukaz of authorization obtained from it, exactly as Russian companies, save certain exceptions. A Turkish rule of November 25, 1887, imposes similar provisions. Same regulation, or almost the same, in regard to joint stock companies in Austria, in Romania, in Brazil. We must then modify this to positive system by saying that the approbation given to the statutes of a company communicates to it a certain nationality only if this company realizes certain conditions, in other terms, has already virtually the nationality of the state whose authorization is solicited. In Greece, the preliminary individual authorization is imposed on national joint stock companies differently from foreign joint stock companies, which can obtain, under reciprocal conditions, a collective authorization accorded by a law, a decree, or a treaty belonging to all the companies in the same country. The authorization in no wise determines the nationality of imaginary beings, but supposes it already accomplished. This supposed solution leaves the problem untouched. Second system. The nationality of a corporation is determined by that of the country within whose jurisdiction it has been organized. This system has been maintained with much conviction by the majority of speakers who participated in the congresses of joint stock companies held in Paris, Indiana 18899 and 1900. This system is marked, in effect, on first examination by a twofold quality very much appreciated by practitioners: simplicity and clearness. The constitution of an imaginary being in a certain country is a fact as easy to verify as the birth of a child upon a certain territory. This system is also, they say, very rational. A corporation born in the domain of a state under the empire of its territorial sovereignty, ought naturally to attach itself to it. Indeed, the corporation is a contract, for all that which concerns the formal conditions of voluntary acts is determined by the law of the place of organization in virtue of the rule locus regit actum. This same law governs, according to the opinion commonly admitted, the greater part of the substantial conditions and the effects properly called of the act in case of silence or of insufficiency of these provisions, for it is to this law that the parties have, in all probability, referred themselves when their wills concurred upon the subject matter of their agreement. The corporation is born of the works of someone, it is constituted in a country in order to be something, and it is very natural that it be made that which the authors themselves wish to make it. If an act creating a corporation is passed in a foreign country, it is that the corporation may have the character of the country where the act shall have been passed. If you do not wish to have the English nationality, do not go to England. Why should this will be inefficacious? When any man can live anywhere where he is not born, there exercise a trade or a profession without thereby losing his nationality, when any man has the right of adopting a nationality other than his own without thereby losing the international benefits in the countries in respect to which he has committed a definite act of abandonment, the right would be denied a company to choose the laws under which it intends placing itself. The advocates of this theory willingly acknowledge the facilities it offers for fraud, but they waive the objection by observing that fraud vitiates all that it inspires and that no account will be taken of an organization of corporation fraudulently effected in a foreign country. They neglect, unhappily, to point out under what conditions the exercise of a recognized power can be fraudulent. From the moment that the nationality of an artificial person is made to depend on the will of its organizers, it ought to be said when and how this will cease legitimately to be exercised. On reflection, this system appears much less simple and less clear than at first approach. In what consists exactly the fact it proposes? What do its advocates mean by constitution, act constitutive? Does it suffice that the instrument, properly called, which contains the agreed clauses has been signed in a certain country in order that the corporation which it rules may take the nationality of that country? Is not this nationality rather that of the state conformably to whose laws the organic act has been published? How to decide, may be said in passing, if many organic acts have been passed and published simultaneously upon many territories. Is not this vague expression susceptible of clothing yet other meanings? What is meant by the place of constitution? A corporation is not constituted solely by a notarial act. There are other things. There is the total subscription of shares, the payment of all or a portion of each share, meetings of the shareholders, votes. There is an entire organization without which the corporation is not validly constituted. To this pressing question of the President of the Congress of Joint Stock Companies in 1889 the stenographic report records no response. If one was not given, it is perhaps that the advocates of this solution were not entirely settled as to its meaning. Third system. Nationality of the stockholders. A corporation or association, being in reality only a group of individuals bound by reciprocal engagements and common interests, has no other nationality than that of its members. In maintaining this opinion, with his habitual clearness, M. de Vers does it without distinction, if not without restriction. His followers are not so logical, they limit its application to civil or commercial personal companies and associations. Thus restricted, this system produces a very favorable impression at first view. A co-partnership, all of whose partners are German, seems at first sight to be German, even if it has the object of exploiting a business in Paris. A club, a company of mutual insurance, composed of Frenchmen living in London, produces equally the impression, perhaps superficial and incorrect, but in appearance clear and distinct, of something French. The trouble begins when one seeks to justify this instinctive and spontaneous opinion. Why, then, should associations, partnerships, or limited partnerships, at least by interests, and civil companies clothe themselves with the nationality of their associates? Two explanations, perhaps three, are presented to the mind. According to the first, the corporation or association takes on the nationality of its organizers or of its members, at least that which they had from the time of its constitution, because it is this nationality which they have in all probability intended to communicate to it. New application, very doubtful, of the famous principle of the autonomy of the will, which I shall attempt further on to define in its relation to this matter. According to the second, associations and personal companies have not a personality distinct from that of their members, they are simply these members united by a contractual lien and considered as such. The patrimony of the members is liable, indeed, for the social contracts, which shows that it is not distinct from them. Even so, bankruptcy, interdiction, death of one of the associates jointly held dissolves the company. This company, then, at the moment of its constitution puts on the nationality of its members. It is in the same situation for all that which concerns the personal statute and the obligations imposed on compatriots or foreigners. What more natural, since it is only the associates themselves? The civil personality, says M. de Versommières, is only a light veil thrown over the associates in order to unify their group and condense them into a single person, which is not distinct from them since it is they themselves and is composed only of them. Its nationality can be made only of theirs. Applied to joint stock companies, as this author does not hesitate to do, this idea seems untenable. The judicial condition of a joint stock company could not without absurdity depend on the numerous and uncertain nationalities of momentary holders of all the fractions of their capital and vary with them. So M. de Versommières modifies his principle in the application he makes of it to those companies in a way that transforms it into a wholly different theory, to which we shall have to refer, and which subordinates the nationality of personal groups to that of their dominant element in leaving the judge to seek arbitrarily the characteristics of this element. Considering only companies of persons and associations, this explanation merits refutation. It has been very simply done by the following consideration. From the moment that the company has a patrimony and domicile of its own, it cannot be seen why it is not capable of having a condition distinct from that of its members. It is true that it is affected by bankruptcy, interdiction, or the death of these members, and that in this sense its personality can be said to be bound to theirs, but, on one hand, this dependence is not essential and can be put aside in French law by the Act constitutif. On the other hand, the induction that is pretended to be drawn from this cause of dissolution is extremely feeble. That which it is necessary to consider for determining the nature of the social personality is this personality itself and not the causes of death which threaten it. While this personality lasts, it must produce in principle its effects within the limits which are traced for it by the sovereignty on which it depends. Extended to all corporations and associations, or restricted to joint stock companies, this theory, whatever may be the justification given it, meets, when applied, such difficulties that it is not very often of any utility, unless it is transformed as this author, whom I have just cited, has done. Is the fact upon which it rests at least susceptible of being combined with other presumptions and completing them in a way either to facilitate the judge in discovering the competent law or in permitting him to counteract fraud? I will examine this farther on. Modifying the explanation, whose presentation has just been given, in a way to maintain the distinction generally admitted between the personality of the corporation and that of its members, it can yet be said that the corporation ought to be ruled by the domestic law of its members and assume their personal statute, because this law, at least in its imperative or prohibitive provisions, has been imposed with a view of protecting the members and of enlightening and directing their will, whatever may be the place where this will has been expressed and whatever may be the situation of its object. To formulate this idea is to refute it. Evidently, the rules upon corporations have nothing in common with the condition and capacity of the members, and relate only to the corporations themselves, at least, domestic corporations. Fourth system. Country of subscription or domicile of the majority of the shareholders at the time of subscription. This theory is not a simple variant from the preceding one. One can, it is true, present the fact upon which it rests as a sign of the will of the parties and presume that the signers of the social act or those who have adhered to it have chosen for their corporation the nationality of the state to which they attach themselves, either by their nationality or by their domicile. but it is not upon this ground that its principal advocate seems to place himself. According to M. Thaler, the raison d'etre of the provisions relative to the constitution and the operations of corporations is to protect the domestic capital and defend the interests of their holders against the dangers pertaining to enterprises organized under form of corporation. So it is the law of the country where this capital is collected in view of such an end which ought to be followed for ruling the agreement which is established under its aegis and obeys in form and substance its prescriptions. Indeed, the stockholder ought to have representatives of the management upon the soil of his country. He ought to be summoned to the general meetings which will be held in the same country. He cannot be made to go 1,000 leagues from there in order to take part in deliberations sanctioned by a law whose purport even he knows not. It is then in its territorial resort that should be found, if not its only social seat, at least a social seat. For, in the opinion of M. Thaler, as in ours, it is the social seat that determines the social nationality. In other words, the corporation takes the nationality of the country where its capital has been subscribed and even the nationality of each of the countries where this subscription has been able to be carried into effect, for the eminent author has not shrunk from this consequence of his doctrine, without nevertheless concealing from himself the evident complications that follow in its train. Why do not the organizers execute as many distinct acts with series of capital belonging to each of the states where they intend placing their shares, even if these contracts should be exactly the same? In the discussion of the multiplicity of failures, when an international corporation ceases its payments, the capital is cut up into as many slices as there are states holders of social values. A process of the same kind applied to the formation of the social property and to a parallel management is not irrealizable. Would it then be necessary to recognize in the corporation as many domiciles and personal statutes as there are countries where the subscription has been effected? In no wise. It is only necessary that in each of these countries had taken place a fraction of subscriptions sufficiently important for the tribunals to consider. Such is, presented in its large lines, this curious and original system, which, by determining the nationality of the corporation by the seat of its domicile, places this in the country of the subscription. Its practical results seem unsatisfactory. It suppresses entirely the right of the parties to establish the social domicile where they wish, a restriction at first view quite arbitrary, perceiving in a corporation only the agreements occurring between the members, as if the corporation itself was not distinguished from them, as the effect is distinguished from the cause. It declares strictly territorial the legislative provisions relating to these agreements, at least when they relate to a joint stock company, in this sense that it submits them, in their conditions of form, of substance, and their effects, to the legislation of different countries where they are concluded among a number of persons which the judge estimates as sufficiently large. Its application at first view appears complicated, laborious, impractical. It leaves a vast field to the personal estimation of the judge, which is to be regretted. Finally, it does not even seem conformable to these agreements which it supposes tacitly intervening between the organizers and each domestic group of subscribers. These have not apparently considered the inextricable complications of which M. Thaler speaks. However evident he supposes them, they have been obliged to foresee that the company of which they became members depended, from the point of view of the personal statute as from many others, on the state to which a natural relation of appurtenances and of dependence, a veritable nationality, binds it. Can it be said that the fact of the subscription of the social capital in a certain country implies a relation of this kind? The whole question is there. Why should it imply this relation? Because those who subscribe to the conditions of the act constitutive in a country and pay their social parts are regarded as subjects of this country, or they have their domicile. More probably, and such appears indeed the reason which inspires M. Thaler, because these persons, whatever may be their nationality or their domicile, contract under the protection of the public power and the law of this country, and that the corporation, result of their contract, ought to depend on this authority and this law. Both of these explanations could as logically impose the fixing of the administrative seat of the corporation at the domicile of the majority of the subscribers. It is this which was proposed, at least by additional title, at the Congress of Companies in 1900. Both are inadmissible. The first is very often contrary to the reality. The capital collected in a locality does not necessarily spring from it, but has ordinarily been drained from almost everywhere. Those who have paid it are often only those who have lent their names, or middlemen, such as a syndicate of bankers that proposes to give back to their customers the shares which it has subscribed. Anyhow, the laws upon corporations have nothing in common with the capacity of the members, less yet with that of the organizers or the subscribers. The second attaches an undue importance to a circumstance very often accidental, secondary, and foreign to the corporation itself. The considerations which have determined the choice of establishments of credit situated in one country rather than in another as instrumentalities of the subscription are almost always drawn from the financial or monetary state of the market in this country, abundance or scarcity of money, political events, taxes on brokerage or commission previously deducted from the issuance, transient condition which influences during certain periods capitalists toward certain enterprises, etc. These are some of the reasons that determine the organizers to appeal to the public in England or in Germany rather than in France or in Belgium. No logical lien then binds the corporation to the states upon whose territory its capital has been subscribed. The element to which it is fitting to attach itself to determine the nationality of the corporation must be sought among the attributes of its personality and cannot be borrowed from extrinsic facts, even though they should have occurred occasionally at its formation. Fifth system. The nationality of the corporation is the same as that of the country where it has its principal place of business. Indeed, ask the advocates of this system, for what corporations have the different states imposed provisions on this question? Evidently, for the corporations whose principal establishment is upon their territory. Each state claims as its own and treats as domestic the corporations that realize this condition. Claim very justifiable, for the corporation attaché is itself naturally to the state whose organization protects it, by the authority of which it exercises its activity. Where can be found a more logical lien, a fact implying in the same degree dependence, appurtenance, and therefore subjection? These considerations seem just, they have attracted the almost unanimous support of doctrine and jurisprudence, and have inspired the Belgian, Italian, and Portuguese laws. It remains to know what is meant by the expression domicile applied to a corporation. Here the understanding ceases. By the terms of Article 102 of the Civil Code, the domicile is the place of the principal establishment. But where is the principal establishment of a corporation found? Is it to be placed in the country where it realizes directly and materially its aim, where it has, in a word, a center of exploitation? Is it not rather in that country where it forms its decisions, where its impulses start from, where it has its administrative center? In favor of the center of exploitation it is of but little consequence as a reason, moreover very serious, that its meaning is to withdraw as much as possible the fixing of the nationality of companies from the will of the organizers, in order to render all fraud impossible. It is that it does not then depend on an accident, an arbitrary fancy or a choice inspired by the perspective of an interest perhaps illegitimate, but on a circumstance drawn from the nature of things. It seems natural, sem. Lienken Renault, to think that the legislator has made laws for the corporations which exercise their profession in the territory upon which it has legislative power. These are the corporations with which the legislator is interested in dealing. It is very just, but the question is exactly to know if the corporation cannot be said to exercise its business there, where its administrative center is established. It is necessary, the advocates of this opinion say, to distinguish the action, realization of the social will, which consists in an expressed decision, and which is accomplished only at the social seat, from its material execution which operates everywhere where the need of it is felt. Now, the place where the corporation lives, the territory where it operates, exercises its activity, realizes its end, is that where it acts and not that where its acts produce their effects. The first is fixed, easy to determine, it can have only one; the second is uncertain, multiple, variable. Therefore there should be no hesitation between the two. A person cannot be said to be domiciled everywhere where he exercises his faculties, but only there where he principally resides with the intention of their reuniting all which concerns his interests and his affairs. Likewise for the corporation whose domicile is shown by the principal organs of direction, administration, and control councils, meetings, agents, offices, bank, which deliberate, act, account, distribute for the social person and represent it with third parties. If this pretended domicile is fictitious, that is to say, does not correspond really to what it ought to be by definition, having been established for defrauding the competent law, the judges will take no account of it in the determination of the nationality, and will seek on account of that the true social center. It is equally to the judge that those apply for whom the social domicile is confounded with the center of exploitation when the corporation, which is often the case, operates in many countries between which it is necessary to choose. Sixth system. The judge shall determine the nationality of the corporation in accordance with the facts which have been enumerated, completing them, if necessary, with others. The real solution, according to this opinion, ought to be sought after in a combination of the systems herein before presented, and which are not entirely satisfactory, neither one nor the other, each of them, as it has been easy to see, being true only relatively and in certain cases. Not only, indeed, have all of them been conceived only in consideration of commercial corporations, separated from other imaginary beings, associations, endowments, and even civil corporations, but no one of them applies at the same time to corporations of persons and corporations of capital. Their meaning being thus restricted, it is yet necessary that they reach it in a satisfactory manner. When the criterion proposed by their advocates is not too notoriously insufficient, it appears inapplicable, at least in certain cases. The opinion which submits a corporation to a state upon whose territory its act constitutive has been passed or published attaches a capital importance to a fact which is not, without doubt, to be neglected, which can even serve as an additional and accessory presumption, but which is too accidental, secondary, contingent, in a word, too insignificant by itself to determine the nationality of the imaginary being at whose formation it has participated, as well as other circumstances. We have therefore unhesitatingly laid this aside. That which applies to the nationality of the members is evidently inapplicable to a corporation composed of members of all nationalities, restricted arbitrarily to the case of a corporation all of whose members are fellow countrymen. It leaves without solution a difficulty of such a nature as too often present itself, that of a change in the nationality of the members. Is the nationality of the corporation going to change in such a case? How, moreover, establish the nationality of shareholders of a joint stock company, impersonal and variable crowd, wave without individuality that traverses the company and constantly renewing itself by means of its transactions whose certificates are the object, without the company's ceasing for a moment from being itself in the course of transformations sustained by its elements? Useless to insist upon the defects of the criterion drawn from the country or countries of subscription. Solution that supposes, moreover, admits one of the two following, and limits itself to render it entirely irrealizable. The theory that subjects corporations to the sovereign of the country upon whose territory they have their domicile meets many difficulties in application. Whatever be the meaning of this equivocal term, if it means administrative seat, a satisfactory solution is obtained in almost every case, not only judicially but also practically, and yet it will sometimes be insufficient. This may be the case, either when the management is exercised in many different countries, or when the organizers have better reasons, interests the most serious and most legitimate to constitute their corporation in attributing to it such a nationality. For example, that of the state upon whose territory exploitation is exercised, even in establishing its social seat in the territory of another state. As example of this last hypothesis, let it suffice to cite the case of the Company of the Suez Canal, whose statutes declare it Egyptian, although its council of administration and its meetings of stockholders are held in Paris. To realize the first, let us suppose a co-partnership composed of 3 partners who manage 3 commercial houses of equal importance in 3 different countries, and at the head of each is one of those partners, or, indeed, a joint stock company organized in view of exploiting tramways in an Italian province where is located not only the technical director and delegate administrator, but a council of local administration clothed with very different powers than those exercised by the council of administration which sits in England, as well as the meeting of the stockholders. Is this company English or Italian? The criterion of the administrative seat does not always suffice, and the system which it proposes needs to be enlarged and completed. It is yet less accurate to use the expression social domicile in the sense of seat of exploitation. In this case it applies very well to corporations that have a purpose essentially territorial, like the concession of a mine, canal, tramway. On the other hand, it in no way applies to corporations that have many centers of exploitation, nor to those whose purpose, capable of being carried on successively or simultaneously at all points of the globe, consists in services, prestations, the working of an idea, processes, or patents. Such is the case of a corporation of banking or of insurance, especially if it has establishments in many countries, of ocean navigation, of metallic bridge construction, or railroads. What will be the nationality of a company formed for colonizing unexplored or half-savage regions? It is truly too easy to refute this system by absurdity, and its advocates do not escape the decisive objections directed against it when they make the determination of the place of exploitation a question of fact to be settled by the tribunal seized according to the importance of such establishment or such center of affairs, or yet when very arbitrarily they fix, once for all, the nationality of the corporation according to its principal center of primitive exploitation without preoccupying themselves with the transfer that can be made of it into another country, nor of those that it is susceptible of creating moreover in the event. Indeed, to refer to the judge, Asm, Lyon and divers sommeliers submit themselves to complete or rectify their respective system when it is inapplicable, by the consideration of the dominant element or of the country for which the corporation has been principally constituted, there is to abandon at least partially this system to the profit of the elective opinion which replaces or completes some by the others of the criterions proposed, and which it remains for me to examine. In what exactly does this opinion consist? The rule that it gives is extremely simple, without obliging oneself to seek such or such circumstance to the exclusion of others. the judges ought to separate and conspicuously show the facts which are of such a nature to attach the artificial person to one of the sovereignties in whose domain it relates, afterwards to establish a balance between them. After having separated all the reasons proper to determine their decision, they will draw from them the result and will judge in this sense. The social seat, the law under whose empire the corporation has been formed, the place of its exploitation, the nationality of its members are only elements whose ensemble alone permits an exact appreciation which will vary according to the nature of the corporation, its composition, its object, etc. Considering, concludes a celebrated decision of the Court of Cassation, that in deciding, in spite of this ensemble of circumstances which characterizes a French corporation, that the above corporation, terminal of Cadiz, has the quality of a foreign corporation, the judgment attacked has violated the said article of the above-mentioned law. Under this positive form, this system so far as this name can be given to the denial of all system, is evidently untenable. To let the judge determine according to his impression, to give him for rule to follow no rule but to determine the nationality of a person at fancy and basing his conviction upon the facts or upon the circumstances that he will be pleased to choose, is a solution that has nothing judicial, that is even contrary to the fundamental notion of legal science. The trouble and uncertitude which would result from its adoption is easy to imagine. Either one of the opinions he intends substituting for it is then preferable, for it is 100 times better to have a narrow and false rule than arbitrariness and fancy. Restricted to the determination of the principal establishment from which results the nationality of associations and corporations, this theory becomes more tenable, and there is little wonder that M. Vavasseur, and after him, Civil and Arthes, has adopted it. The administrative seat being in one place and that of exploitation in another, where will be the principal establishment? Asks this author a very delicate question. He answers, subordinated to an almost arbitrary appreciation of the judge, for it will vary according to the circumstances and the particular cases, therefore it has occasioned apparently different solutions. And he cites many judicial decisions that are indeed contradictory, these placing the principal establishment at the administrative seat, those at the seat of exploitation. Even restricted in this special hypothesis, this dangerous power given to the judge to determine a right of capital importance according to the elements which are left to his discretionary appreciation without moreover tracing for him a rule or giving him any directive idea appears fertile in contradictory judgments, incompatible with the security of affairs, irrational, and impractical. If there is a motive for taking account of such a fact, in such circumstances, and of such other, in such other circumstances, it is important to deduce it once for all without abandoning the search of it in each case to the arbitrary appreciation of the judge. It is that which I am going to try to do.